Hello and welcome to the big picture. In one of the most significant judgments politically, AIDMK Supremo Jayalalithaa has been acquitted of all charges of owning disproportionate assets by a single judge of the Karnataka High Court. It took 19 years for this case to reach this stage, and after a special court judge in Bangalore had convicted her and 3 other associates of hers having amassed disproportionate assets in September last year. However, the High Court judge who acquitted her yesterday said that the disproportionate assets were only to the tune of just rupees 2.82 crores, which is less than 10% of her income. However, larger questions have been raised over the acquittal relating to the procedures adopted while deciding the appeal in the High Court. The fact that the Supreme Court had found that the appointment of the Special Public Prosecutor Bhavani Singh, who appeared in the appeal before the High Court, was illegal is one of the major issues. Then the fact that a new public prosecutor was appointed after the appeal had been heard and judgment had been reserved, and he was not allowed to present his case but was asked to give written submission in a day's time is also another issue. In the light of this and other issues which have cropped up, the question is, has justice been done by the acquittal of Jayalalithaa and her associates? And more importantly, what next? We will discuss all this today with KTS Tulsi, senior advocate in the Supreme Court and an MP in Rajya Sabha, Justice B.A. Khan, former Chief Justice of Jammu and Kashmir High Court, who will be on the phone line from Bombay, Sanjay Hegde, advocate in the Supreme Court, and Sachidananda Murthy, resident editor of the Week magazine. Welcome to all of you. I have to inform here that despite our best efforts, no one from ADMK or its lawyers were available for this program. Anyway, Justice Khan, does this judgment sound as a fair one, and or does it cause any concern to you?
Now, what makes one to think that it is not clear? If perception is because Mr. Acharya, the newly appointed special prosecutor, was not heard, but his written arguments were before the court. See, one has to see the totality of the circumstances, whether one side prosecution has gone totally unheard. Now, unheard doesn't mean when your written arguments, elaborate arguments are before the court, and oral arguments in that case only help in making certain clarifications. So this is not a case where one side has gone totally unheard, so that it can be said that principles of natural justice have been violated and so on and so forth, or that the judgment proceeds on one-sided, the appellant's case only. The appellant's lawyers have been heard and so on and so forth. But if there is anything more which leads to some kind of a doubt of unfairness in rendering the judgment, that's a separate matter altogether. But what I feel is, see, Girish, the position is that in this kind of an adversarial litigation, a case can be decided only against one party and in favor of one party. When Jayalalithaa was, the case was decided against her by the special court, at that time it was very much, everybody said good. Now, in a system when the superior court upsets that judgment for reasons good or bad, which can only be tested by another superior court like Supreme Court, then we should wait and see what is wrong with that judgment. Okay. So in the hierarchy, a superior court decides in our favor, that decision should be accepted.
Okay.
If there are loopholes in the judgment, if there are any infirmities or defects, those will be gone into by another superior court, that will be a Supreme Court if somebody approaches the Supreme Court. Now, till then, talking of this, I heard somebody saying that it's a black day for the judiciary. What makes one case decision in one case a black day for the judiciary?
Okay, so well, while all your points are well taken, only the concern seems to be of certain people that the way the special public prosecutor was first appointed. We'll come to that. Anyway, your points are well taken, Mr. Tulsi. Mr. Tulsi, the question is this, that here was a special public prosecutor who had been appointed by Tamil Nadu. When it is said, when it is argued by some people that actually it should have been the Karnataka government which should have appointed the special public prosecutor, even in the appeal in the High Court. Would you agree with that? How do you look at this?
No. You see, this prosecutor Mr. Bhavani Singh
Right.
was appointed by Karnataka on the suggestion of the Chief Justice of Karnataka at the stage of trial. Now, when he is appointed, my understanding of the law is that the prosecutor, special prosecutor under section 24 clause 8, continues till the end of the proceedings. Now the Karnataka, after the appeal is filed, Karnataka took no steps for ensuring that the state's interest is represented, if not by Mr. Bhavani Singh, by someone else. They took no steps at all. It seems that there were parties, there are vested interests which were only interested in delaying the proceedings, and that's why nobody was appointed. When nobody was appointed, the state of Tamil Nadu merely notified the same prosecutor who had been appointed during the trial on the recommendation of the Chief Justice by state of Karnataka to continue. It's not that the Tamil Nadu state tried to impose somebody from their own. It is only to ensure that the time frame which was prescribed by the Supreme Court was adhered to, that a certain step was taken. Now that was, you see, earlier the law used to be that in a criminal case, even if there are a million questions of law required to be gone into deeply and answered, it can only be done at the behest of either the accused or the state. But here, the political adversaries, when they are allowed to jump into the proceedings and cry a halt time and again, it's becoming more and more difficult for courts to be able to speed up and deliver the final verdict.
Mr. Tulsi,
in this case, if the justice has been done, it's been done after 19 years.
No, Mr. Tulsi,
that process is a punishment.
Mr. Tulsi, you said that, according to your understanding, you think that a special public prosecutor who is appointed in a case should continue or will continue right up to the last stage of the case.
Yes.
But here was a Supreme Court which said that this appointment was illegal, and they removed him. And just a few days before the judgment, after the judgment had been reserved, he was removed. His appointment was called illegal by none other than the Supreme Court. How do you explain that?
No. Supreme Court merely said that the appointment order ought not to have come from state of Tamil Nadu. But the Supreme Court, during the hearing, also repeatedly asked the state of Karnataka, why did they fail to take any steps? Why did they not make sure that the time schedule prescribed by the Supreme Court was adhered to? And for that purpose, they ought to have facilitated the hearing. But perhaps Karnataka state wanted to delay the proceedings for whatever reasons.
Sanjay Hegde, how do you look at the role played by Karnataka government in this was also quite crucial actually. As Mr. Tulsi is saying, why didn't the Karnataka government take interest in it when it came to the appeal stage?
The Karnataka government, quite frank, for the Karnataka government, Jayalalithaa is a sort of unwanted guest. She was transferred without the Karnataka government asking. It was only when Tamil Nadu politicians said that you can't have a fair trial in Tamil Nadu that the Supreme Court first transferred it. At every stage, you will remember that when the trial judge sentenced her, then there were almost anti-Kannadiga riots elsewhere. The state of Karnataka always plays it cautiously according to the rule book. What happened in this case was that the prosecuting agency, even today, is the DVAC, the Directorate of Vigilance and Anti-Corruption in the state of Tamil Nadu. The trial has been shifted to Karnataka. Now, the roles sometimes tend to get confused because at that stage, Mr. Acharya was appointed by the Karnataka High Court, but his fees and everything were still paid by the state of Tamil Nadu. There was some lack of clarity on what was the prosecuting stage, the prosecuting state. Therefore, it wasn't quite sure whether the prosecutor appointed, the appointment was by the High Court on behalf of the state of Tamil Nadu or the state of Karnataka.
Hasn't that confusion been cleared?
Now the confusion has finally been solved by the Supreme Court's recent judgment, where it clarified that while the prosecution agency is that of the state of Tamil Nadu, the prosecuting state is Karnataka. And therefore it had held that the action of the government of Tamil Nadu in appointing Mr. Bhavani Singh was wrong. Mr. Tulsi is quite right.
Isn't it quite? And then the Supreme Court went on to say that there is no need for fresh hearing because I think
there were other compulsions also.
Anbalagan said that there needs to be fresh hearing. The petitioner had said fresh hearing.
The petitioners only wanted a rehearing of the entire appeal.
Right.
But at the same point of time, please, the High Court in Karnataka has thousands of criminal appeals which are languishing. For one case, you have tied up a judge for over 2 or 3 months. You have had volumes of evidence gone through. The judge has reserved judgment. A judgment is almost ready. Was the court to throw out everything for a technicality, or was there a solution to be found? The Supreme Court at that point of time thought that it would be adequate if the new public prosecutor, if appointed, submitted written submissions, and that too were taken into account.
Written submissions, he had only 2 days to give the written submission. Not even 2 days, actually 1.5 days.
Yes, but you must also remember that he was not fresh to the case. He was somebody who had conducted the
Yes, he had conducted the case till 2012, then he had left, then Bhavani Singh had taken over. So the new public prosecutor, special public prosecutor, had no idea what the earlier prosecutor had done.
No, but he was the first public prosecutor. Bhavani Singh was a brief interlude.
Right.
So there is absolutely no doubt that Mr. Acharya was well conversant with the case. But I do admit that 2 days seems very short for even somebody conversant with a huge monster case like this to prepare written submissions. I'm sure that even within those 2 days, he must have done his usual fantastic job.
Justice Khan, that the solution found by the Supreme Court and saying that no fresh hearing, go back, let the new public prosecutor be appointed. He was appointed 2 days. He was given not even 2 days, and then he had to submit his give his submissions in writing. You think that was the only solution which could have been found in the circumstances?
No, Girish, what do you do about it? See, our Supreme Court has fixed a schedule, fixed the last days, and then within that last date, these developments occur.
How sacrosanct is that, sir?
No, it is sacrosanct because you can't say, even if inference is drawn that Supreme Court somewhat bungled or Supreme Court messed up or Supreme Court confused the whole thing, we can't say that. Now, what Supreme Court does is the law of the land. And what Supreme Court had done in this case had fixed up the schedule and the last date, and a judgment had come to be reserved by the Karnataka High Court within that time's limitation. And this public prosecutor controversy came in, and the best solution was asking the public prosecutor, why did Karnataka not appoint? Now, asking the public prosecutor, now if you can't go for a oral hearing this now, file your written submissions. Now, what is the idea of filing written submissions before the court, which is normal? In any other court, if you see the American Supreme Court, for example, they won't allow you to argue for days on, months on.
But here we have that. But here we have that.
And this is more solid because when you file your written arguments, that is more solid.
No,
that's on the record.
But the special public, Mr. Acharya, who was appointed, he is not satisfied. He says that I didn't get enough time to do it.
No,
I was not prepared, and then last minute I was told, and I was not even heard. He has a problem. The special public, the new one, has a problem. Anyway, I'll come back to you, sir.
No, Girish, let me point out that every caution wants to make oral submissions. Every caution is attracted to that kind of a thing. That is why Mr. Acharya must be complaining. But for purpose of court, for purpose of consideration, for purpose of decision, written arguments are better than any oral argument any day.
Okay, Sachi. What were the compulsions of Karnataka government not to have, do you agree with what Sanjay Hegde says, or you think that there were other considerations for the way the government ignored especially at the appeal stage?
No, I think the Karnataka government got a legal opinion from within its own this thing. That's what I've heard, is that Bhavani Singh can continue because its feeling was that he was a prosecutor for the case until the final stage of disposal by the Supreme Court, if there was an appeal lying with the Supreme Court. So I think that was where they were not alert, they were not on their feet. I mean, Karnataka doesn't boast of a very good legal team these days, that much also I can say. So that it was more this thing, error of this thing rather than any political motive. But also regarding the Supreme Court, this is very innovations of Supreme Court. I'd like to point out two other cases. One was the Bhopal gas tragedy, the way the Supreme Court clubbed the criminal and civil issues and made it, nobody was happy with it, but it was not exactly according to the letter of the law, but still it became the law of the country. Then similarly in the Sahara case, I mean, any number of lawyers have said, how can you send him to jail without him being convicted and all that?
10,000
Supreme
crores
Court stuck to it, 10,000 crores you have to pay. But here also there was a similar innovation that they said we are giving bail to Jayalalithaa. Within this date, the appeal has to be disposed of. In how many thousand cases does the Supreme Court say that within these dates, Supreme Court itself does not follow such time deadlines? So
why this deadline?
And to justify that deadline given by the bench when it gave the bail, this another monstrous thing is that the man who argued before the High Court, he has no locus standi, but his arguments will stand. You appoint another man, but he cannot argue.
His arguments will stand.
This for outsiders, it looks a little absurd.
Incongruity. Don't you think, Sanjay Hegde, that this looks incongruous, the way the whole thing has been?
There was a incongruity, but the Supreme Court seemed to think that it had done the best of a bad situation. The sacrosanctness of the deadline was particularly because of the fact that there was an earlier feeling that Jayalalithaa and her team had dragged out the trial for an inordinate length of time. So when she was granted bail, it was a condition of the bail that she would not delay the appeal, and the court thought that the appeal would be finished as fast as possible. Now the bench that granted her bail was that of the Chief Justice of India. The matter regarding the change of the public prosecutor first went to another bench of 2 judges. They disagreed. They referred it to a bench of 3 judges, and those 3 judges were running into a time constraint. You had the fact that the High Court judge had already reserved judgment in March. He is also on the verge of retirement. Any step to have a rehearing essentially meant starting the appeal all over again, and then the earlier conditions which the Supreme Court had said of an expeditious hearing of the appeal could not have been met. So the Supreme Court tried to compress, the last bench had to compress everything together.
Mr. Tulsi, see, as far as this case is concerned, all of you are arguing that Supreme Court had no choice, or it tried to in the worst case scenario, they tried to do as best as they could. But what will be the implication of this in future? Like, if similar cases come up, if similar arguments are made, what will happen in future? Do you see any implications of it in the future?
You see, I think that there is a Parkinson's law, and arguments stretch to time available. I wish this kind of a direction is given in more cases.
Exactly.
Or we fix a time limit for arguments in all cases.
Right.
It is done in other countries. In the United States, the appellant argues for 15 minutes, the respondent for 20 minutes, and rejoinder for 10 minutes. They hardly ever give more time. And that includes even answering all questions of all the judges. The entire court sits together. We need to make our system workable. We can't have the luxury of arguments going interminably. Nobody needs to read judgments in court. Judgments should be deemed to be read. You only have to have bullet points for the purpose of emphasis. I really think that we need to change the way the arguments take place in the court drastically, And this is one way which is shown by the Chief Justice,
Are you,
that you will conclude the hearing within so much time.
Mr. Tulsi,
Yes.
will you
I'm all for this.
will you and your colleagues agree to this kind of a shortened version of hearings, because we have seen the biggest, please don't mistake me for using this word, but if the biggest culprits are the lawyers who take hours and hours and hours to argue. I don't think you can blame the judges
That's
for that.
exactly what I'm saying. Now, I'm not blaming the judges. I'm only saying that we need to change the system. And lawyers and judges need to agree to this, that there will be a time limit within which you have to argue. We need to
Okay.
accept that
Okay.
the Parkinson's law is binding on everybody.
Okay, Mr. Tulsi, now the question is this: what next? Will who is the onus as far as the appeal is concerned? There still seems to be some confusion about that. Some people are saying that Karnataka government has to do it. Some people say Tamil Nadu government has to do it. Who has to? If there has to be an appeal, who should go in appeal?
I don't know, I can't say, but there are precedents. I needn't express an opinion on this because I haven't examined this issue in depth. But I would say that whatever has to be done, we should bear in mind the fact that it has taken 19 years for the High Court to render a verdict.
Right.
Because it became a match between the political adversaries, and when political adversaries are allowed to have their say day in and day out in the course of a trial of a political opponent, then it becomes a political slugfest. And we need to avoid that. In the courts, only state should have the state which is prosecuting, the state alone should have a role, and the accused. That the neutral umpire is the judge. Why do we need political adversaries to come and raise these issues?
I don't think
the
anybody.
Supreme Court had earlier maintained all the time.
Okay, I agree with you, but the fact is politics comes into play, and in this case we have seen foes turning friends and friends turning foes over the years. Sanjay?
Absolutely. Well, the original complainant was Subramaniam Swamy, who then joined Jayalalithaa, brought down the government in Delhi, then thereafter again fell out with her, and has even put in written submissions in the Karnataka High Court.
Right.
Despite his party, the BJP, being somewhat friendly to Jayalalithaa right now. So let's not get into the politics of it. Here was a case where...
I'm talking of the appeal now.
As far as the appeal is concerned, I think it is a logical fallout of the Supreme Court's 3-judge bench decision, which said that the prosecuting state is the state of Karnataka, that it would become incumbent upon the state of Karnataka to pursue an appeal if it was so advised.
Sanjay?
Now, my question to Mr. Hegde is, the prosecuting agency is still the DVAC of Tamil Nadu.
The investigating agency.
Investigating agency. So,
The work of investigation is over now. There is no work of investigation left.
No, but then...
That is the investigating agency.
No,
investigation is over.
will it-
The prosecuting state is the state of Karnataka.
What if it tells the prosecuting state, don't file an appeal?
Then that would be a
Because
question of law worth
the
examination.
prosecuting state
If the
always
DVA
consults the investigator. Look, it has been set aside. So,
Justice Khan,
Jayalalithaa will control DVAC.
Justice Khan, isn't this a tricky situation now? Who should file the appeal?
No, I would agree with Sanjay. Since Supreme Court says that prosecuting state would be the Karnataka state. But see, again, the problem is the investigating agency is the Tamil Nadu. And the entire time that most of the prosecution during the trial took place. So it was a very complicated situation. In fact, if you look in totality, I feel that Jayalalithaa was dealt with harshly by the judiciary. At the instance of a political opponent, the case was transferred to Karnataka. Now in Karnataka...
This was after 70 witnesses somersaulted and they went back on their statements which they made. I think after that the case was shifted to Karnataka in 2003.
All I'm saying that judiciary has not been in favor of somehow helping or protecting as is the common perception Jayalalithaa. See, what is happening, Girish, is that whenever a judgment goes against some celebrity or an infracted person, then we cheer it up, oh, judiciary, judiciary. And when it goes in favor of that celebrity or infracted person, we say, no,
No,
something
we are
must
not, sir, this is not just
what
another...
all I'm saying, Karnataka will not be as a prosecuting stage, as much enthusiastic about filing appeal as it would have been otherwise, for example, if it was a normal case. But the government now, see, Jayalalithaa was removed as a chief minister by the judgment of that special court. It
Yes.
was a very special case that way. So if it had to be concluded in such a limitation, then you can't apply same limitation to all routine cases. You have to see that aspect also. The interest of justice demand a totality of the circumstances to be taken into consideration.
So
Now,
you-
Karnataka state may not be as enthusiastic in filing an appeal. Now, in that case, it will be again perhaps presumed that there must have been something going on in the back doors to not filing an appeal and so on and so forth. But as on today, I maintain it for the judiciary, that the judiciary, if it is following its hierarchy, if it is a process, please accept that process, and that...
No, we are accepting.
One way or the other.
Absolutely, we are accepting that process, sir. Mr. Tulsi, now if let us assume that the Karnataka government is not interested in appeal, can the original petitioner, one of the original petitioners, appeal in the Supreme Court against this judgment? Or the intervener?
You see, the entire concept of state being the prosecuting, the aggrieved party is the state, the people, and in order to avoid private parties having a slugfest in the court and wreaking private vengeance,
Right.
it is the objectivity which is required in the matter of prosecution, and that is why the prosecution as an agency is vested with the authority to prosecute.
Right.
Now, prosecutor has to be very fair. He has to form an opinion. Here the prosecutor is already expressing opinion on the television channels that so it seems that he's very anxious to file an appeal. I don't know what's going to happen, but I believe that the state has to be fair to the accused as well as to the people.
Okay.
It does not have to have a partisan attitude.
Okay.
The prosecutor also must remain alive to his responsibility to the people.
Okay, sir. Okay. Sanjay, very quickly.
Well, the prosecuting state is the state of Karnataka. It cannot long delay the decision.
The decision has to be taken sooner rather than later.
Absolutely, it will no doubt act on legal advice. And the fact that the Supreme Court is shut for 2 months, I think is long enough for it to take a decision.
Take it. Okay. Sachi, do you think? No, my question is: do you think that the state of Karnataka, the Chief Minister of Karnataka, who has to ultimately take this decision, will be guided by what the Congress High Command has to say on this in this matter?
I don't think so, but then I think the Chief Minister of Karnataka should make it clear.
But you agree that this is become a political issue.
Political issue. That's why the Chief Minister of Karnataka should make it clear that whatever the special public prosecutor who has been appointed on the basis of the Supreme Court 3-judge judgment, whatever he says, if he says go in appeal, Karnataka should go in appeal. If Acharya says don't go in appeal, okay, so leave the matter to the special public prosecutor.
Okay, I think on that note we'll end. Whether it will be left to the special public prosecutor or what the Karnataka government will do now, and also some of these various questions which have been raised over this. But as Justice Khan says that we'll have to leave it to the hierarchy to decide what ultimately should happen. We'll wait and watch what will happen. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.